Morning, everyone. Welcome to the sixth part of our lecture series for the subject Correctional Administration. And on this lecture series, we'll be discussing more on the jail operations. Likewise, we will include in our discussion the different laws affecting the maintenance of an offender in an institutionalized setting. Okay, so of course, what is important in this discussion is for you to be aware of the different laws, okay, as well as on some of the procedures that are undertaken, okay, as far as jails are concerned, okay, particularly on the operation of the Bureau of Jail Management and Penology. Okay, so first question for this part. Okay, so what is specific law created the BGMP in place the same under the DILG? Okay, so choices are RA 6975, RA 8551, RA 9263, RA 9592, or none of them. Okay, so looking at it, okay, since we are talking about the creation of the BGMP as well as its placement under that of the DILG, it is noteworthy to consider, okay, that the creation, okay, was made possible by virtue of Republic Act 6975, okay, otherwise known as the DILG Act of 1990. Okay, so as far as this law is concerned, okay, under Republic Act 6975, it actually transferred, okay, the supervision of the different services under public safety from the Department of Defense, okay, to that of the Department of Interior and Local Government. Okay, so if we are going to consider, okay, prior to Republic Act 6975, we already have an existing law that governs the services, okay, of the police, okay, the jail management service, and the fire safety services by virtue of Presidential Decree numbered 765, otherwise known as the PCINP law. Okay, so under the PCINP law, the PCINP is mandated to perform three public safety functions, namely, okay, the police service, the jail service, and the fire safety services. Okay, so under Republic Act 6975, okay, while it is true that it tried to separate these services, okay, to form three different bureaus, namely the Philippine National Police, the BGMP, and that of the Bureau of Fire Protection. Okay, so some of the important features of this Republic Act 6975 is that it somehow increased the qualification standards, okay, for members of the PNP, BGMP, and that of the Bureau of Fire Protection by means of requiring, okay, new applicants to earn at least 72 collegiate units. Okay, with the, of course, the intention there is to increase this so-called qualification, okay, in order for this public safety service to somehow uplift, okay, the professional standard. Okay, and then of course for the on the part of the Philippine National Police, okay, eventually, okay, the provisions of Republic Act 8551 or Republic Act 8551 was enacted, and after it was enacted, it increased the qualifications as well as it increased the, okay, salary of the members of the Philippine National Police, leaving behind its sister agencies, okay, in the BGMP and that of the BFP. Okay, so what happened there is that, okay, the members of the BGMP and BFP wanted also, okay, similar law to that of Republic Act 8551 that would somehow uplift the qualification standard and also to increase their salary. And true enough, okay, by virtue of Republic Act 9263, okay, by virtue of Republic Act 9263, okay, it increased, okay, the qualification of the members of the BGMP and that of the BFP, and correspondingly their salaries also increased. Okay, so under Republic Act 9263, okay, all members of the BGMP and BFP are now required to finish a baccalaureate degree So they are given actually a period of 5 years from its enactment, okay, on March 10 of 2004. So they are given 5 years. So they are given until March 10 of 2009, okay, to satisfy all the requirements, okay, as far as the educational qualification is concerned, okay. So unfortunately, comes 2009, majority of the members of the BGMP and BFP are not yet, okay, qualified as far as the educational qualifications are concerned, okay. So what they're looking at is that if they will remove all of them, okay, they will have to pay their retirement fees, and at the same time they needed to recruit personnel, okay, to of course to replace them. And to avoid that, kasi it would be more what you call this, it is budget draining, okay, if they are going to do that. So they came up with another law, okay, by virtue of Republic Act 9592, okay, that extended the period, okay, of attaining, or extended the period of complying with the minimum educational requirement, okay, which was or which allowed, okay, another 5-year extension, okay, for the BGMP and BFP to meet the minimum educational requirements, okay. And the Republic Act 9592 was enacted on May 8 of 2009. Okay, so next question po tayo. So who among the personnel of the BGMP and Bureau of Fire Protection will be excused from the minimum requirements mandated by RA 9263, particularly on the educational requirement? Okay, so again, okay, under Republic Act 9592, while it is true that they wanted, okay, to somehow extend, okay, but despite its extension, okay, it so happened that there are still personnel who were not able to finish their baccalaureate degree. Okay, so that they made a tawag natin dito, they made an exemption. So the exemption here is on letter D. Okay, so personnel, okay, with 15 years, okay, of active service in the BGMP and BFP are now excused from meeting the minimum educational requirement. Okay, but of course, if we are going to consider what is actually happening within the BGMP and the BFP organization, no one is allowed to be promoted to the next higher rank if they were not able to finish their baccalaureate degree. So in turn, even if you are exempted by virtue of Republic Act 9592, however, under Republic Act 9263, there is what we call as an attrition system. Okay, so under the so-called attrition system, if you are, okay, stagnant in a particular rank for a period of 10 years without any, okay, promotion, then definitely you have to be removed, or you have to be retired, or you have to be separated from the service, okay, as the case may be. Okay, so we have here another question. So what is the rank of the chief directorial staff of the BGMP? Now, since we are talking about the chief directorial staff, okay, the chief directorial staff is basically the number 4 man, okay, in the BGMP, in the BFP, as well as in the PNP. Okay, so when we say chief directorial staff, you are the number 4 man. The number 1 man is the chief of the bureau. The second is the deputy for, okay, administration. The third is deputy for operation, and the fourth will be the chief directorial staff. Okay, so in this case, so what would be the rank, okay, for the chief directorial staff? Okay, so the rank for the chief directorial staff is basically, for the BGMP, is basically the chief superintendent. Okay, so why so? Why chief superintendent? Why not deputy director general? Okay, you have to consider this. In the BGMP and BFP, the highest rank available for them is director, equivalent to 2-star general. So it is not proper that, of course, okay, for its deputies, the deputies should have the rank of chief superintendent, because it would be improbable that the chief and his deputy would have the same rank. Okay, so another question. Okay, so what is the rank of the officer in the BGMP before he or she could be appointed as a municipal jail warden? Okay? So, in as far as the position, okay, of a municipal or of a city or municipal jail warden is concerned, it is uniform all throughout the country. Okay? So, as far as warden is concerned, the rank, as far as Republic Act 9263 is concerned, is that they should have the initial rank of, okay, at least chief inspector. Okay, so they need to have the rank of chief inspector. Okay, however, okay, depending on your assignment, if you are assigned in the municipal jail or in the city jail, okay, it aside from your rank, it also follows a corresponding, okay, what you call this, it also follows a corresponding tawag natin dito, it follows a corresponding degree. Okay, so if you will be assigned as a city, okay, city jail warden, okay, you need to have at least, okay, 24 units leading to a master's degree. Okay, so you should have earned at least 24 units leading to a master degree if you will be assigned or appointed, okay, as the city jail warden. Okay, so if you are to be appointed in the municipal, okay, municipal jail for that matter, then definitely you need to earn at least 12 units leading to a master's degree. Okay, so those are the educational requirements, okay, for a city or municipal jail warden. But of course, if you will be appointed as provincial director, something like that, or regional director, okay, for the BGMP, you need to finish, okay, at least a master's degree. So master's degree is very much important. So after your board examination and after joining the BGMP, PFP, or even the PNP at that, okay, you need to seek to further professionalize yourselves, okay, by means of trying to finish a corresponding master's degree. Okay, that is of course aligned with your profession as criminologist. Okay. As far as the appointing authority, who is responsible in the appointment of personnel with the rank of JO1 to is JO4. Okay, so for BGMP personnel, starting with the rank of JO1 to is JO4, the appointing authority basically rests solely on the, okay, regional director. Okay, so basically for GO1 to GO4, the firing and hiring, okay, authority will be, of course, the regional director. But what if you will be promoted to the rank of jail inspector? Okay, so if you will be promoted to the rank of jail inspector or to be promoted up to the rank of superintendent, then the appointing authority will be the chief of the BGMP. Okay, so GO1 to GO4, appointing authority, regional director. Inspector to superintendent, appointing authority, it will be the chief of the BGMP. If you will be promoted to senior superintendent, the appointing authority will be the Secretary of Interior in Local Governments with the endorsement of the chief of the BGMP. If you will be promoted to chief superintendent or director, the appointing authority, of course, will be the President of the Republic of the Philippines. You have to understand that in as far as the BGMP, BFP, PNP, Armed Forces of the Philippines, Coast Guard for that matter, okay, or any public safety service that considers the bearing of arms for that matter. The appointing authority, if they will be promoted to a star rank, should always be the President of the Philippines. Well, of course, the very reason behind is to ensure that there is loyalty among those people who will be appointed. Okay? And then, of course, we have there the reception procedures, okay, that are undertaken in jails. Okay, so this is as far as the BGMP is concerned. Okay, so the reception procedures in jails and that of prison is very much different. You have to understand that in jail, okay, the offenders being committed to them, okay, usually came from, okay, the community at large. Okay, unlike in the Bureau of Correction, okay, that majority of those who are referred to them are already confined in local jails. So ibig sabihin that some of the reception procedures were already undertaken. So if you are going to look at the procedures in the Bureau of Correction, there are only 5. However, in the BGMP, okay, there are numerous procedures that are being undertaken here. Okay, so the first one is, of course, the checking of credentials. So what are the credentials that we are referring to? Of course, what is important here is the commitment order or the mitimus that has been issued by the court, okay, ordering a public officer, okay, in this case, the BGMP personnel, to receive a person for purposes of service of sentence or for detention. Okay, so you have to check on the credentials, including, among others, okay, the medical certificate, okay, of the arresting officers. Okay, but of course, the medical certificate is for the person arrested and the person being referred to for confinement. So dapat okay, the police officer, before referring a particular person for confinement, they need to subject that person already for purposes of medical examination. Okay, on the part of the desk officer of the jail, okay, aside from checking all the credentials, they also need to examine, okay, the arrest report and the authenticity of the commitment order. Okay, baka kasi mamaya, okay, picky yan, okay, and if it is fake for that matter, then possibilities that they could be charged, okay, for arbitrary detention. And then, of course, they need to search inmates for weapons or contrabands. Of course, in as far as searching is concerned, it is, again, okay, it has a graduation. Okay, graduation in the sense that there are series of steps that must be followed, okay, in the conduct of search. So the first is frisking, followed by strip searching, and if necessary, it will be followed by cavity searching. Okay, and then of course, the admitting officer shall take the cash and other personal belongings and prepare 5 copies of receipts. Now, saan pupunta itong 5 copies of receipts? Okay, so of course, the first copy goes to the national, okay, national office of the BGMP. The second one is in the regional. Third is in the provincial. The fourth is on the jail concerned. Now, where does the 5th copy goes? Okay, as far as the receipt of the personal belongings of the inmate, it goes to that of the inmate. Why do you need to give a copy for the inmate? Because by the time that the inmate will be released from confinement, he will have to receive all of the items that was taken from him as indicated in the copy of the receipt. Okay, so after obtaining all of these, or after obtaining the copies, okay, then definitely, okay, all properties and valuables shall be turned over to the custodian for safekeeping. So itatago po yan. Okay, inmate shall be fingerprinted in the photograph. Okay, admitting officer shall accomplish a jail booking report in 4 copies attaching the photograph. Okay, and then of course, saan ulit pupunta itong 4 na kopya? National, regional, provincial, and the local jail concerned. Hindi ba bibigyan yung offender? Hindi na. Okay? Kasi the offender has nothing to do with the copy of the booking report. Okay? And then, of course, to be strip searched. Okay? And then, of course, a thorough medical examination. Okay? Thorough medical examination, again, to determine whether or not he is suffering from any contagious disease, or he might be suffering from any form of what you call these external injuries, which could be life-threatening. Okay, possibility is that they will refer to you a particular offender, and then when he is already inside the jail, okay, he died because of injuries, okay, internal injuries for that matter. Okay, it might as well be true na magiging kasalanan pa yan ng mga BGMP personnel. Okay, now, in the conduct of thorough medical examination, what if there is no physician, okay, or there is no nurse, and it so happened that all of those who are in duty at that particular time are all criminology graduates? So what should be done? So the admitting officer shall observe the mental alertness, overall appearance, in any physical abnormalities, okay, redness in any part of the body, okay, some sort of contusion, okay, abrasion for that matter. They need to take that into consideration, okay, because again, as I have made mention, okay, it might be possible that the person is already suffering from a life-threatening injury, okay, so whatever happens, okay, they need to refer it to the medical personnel. Okay, medical record accomplished by the physician, and then of course a social case study, okay, to be conducted by the by a social worker. Now, of course, the BGMP needs to employ as part of their regular force social workers for that matter, so that the social workers will be responsible in the conduct of the so-called social case study. Sentenced prisoners shall be provided with jail clothing. Usually, the color given to them is yellow. Okay, briefing and orientation, and then of course the maintenance of inmate record or the prison record. Okay, so those are the procedures that are undertaken in the BGMP facilities. Okay, so when an inmate is admitted, okay, when an inmate is admitted inside the BGMP facility, well, of course, there are certain things, because in the BGMP facility, they do not really have a classification of minimum, maximum, or okay, super maximum. But although they have to take into consideration whether or not an inmate is high risk, okay, or offender or not. But more importantly, okay, the most common classification are these. Okay, so in relation to that, this is now the question. Now, who are considered as unusual inmate or offender? Okay, now, if there are unusual inmate or offender, the question is, who are the usual? Yan, yeah? So who are the usual offenders, so that we could also determine who are the unusual. Okay, so the usual group of offenders are adult male Filipino prisoners. Adult male Filipino prisoner. If you are outside, okay, or adult normal male Filipino prisoner. Adult normal male Filipino prisoner. So if you are outside of that category, then you are automatically considered as unusual. Okay, so when we say adult, so if you are a minor, then you are unusual. Okay, adult normal. If you are not normal, mentally and physically, you are considered as unusual. Male, if you are not a male, then definitely you are considered as unusual inmate or offender. Okay? Or if you are not a Filipino, then you are considered to be unusual. Okay? So, to consider that you are a usual, okay, again, you are an adult normal male Filipino prisoner. Adult normal male Filipino prisoner. If you are outside of that category, then definitely you are unusual. So in this case, okay, in this particular question, who do we consider as unusual inmate or offender? Okay, so female, drug addicts, alcoholics, children, rapists. Okay, so on the letter A, 1, 2, 3, 4, 1, 3, 4, 5, 1, 2, 4, 5, or 2, 3, 4, 5. So the answer for this particular question is letter A, okay, 1, 2, 3, and 4. Okay, so to ask you a question, why is a rapist not considered as unusual? Because when we talk of the rapist, we are talking of the crime committed by him. We are not talking here of any abnormality that will actually qualify him as, let's say, unusual, to be outside of the category of adult normal male Filipino prisoner. Now, if that would be the case, if we will classify rapists to be unusual, then it also follows that we could classify a thief, we will classify a robber, we will classify a murderer as unusual. But that is not the case, because as far as classifying inmates as unusual offenders, we consider those people with unusual needs. Okay, unusual needs that is not needed by the general prison population. So what makes the female unusual? The female becomes unusual because they have needs. Okay, they have needs that are not needed by the general male prison population. Okay, of course, they have periods in a month. They have visitors in a month, something like that. Diba? So as far as hygiene is concerned, there is a higher degree of hygiene requirement for female as compared to males. Okay, then of course, drug addicts and alcoholics. Remember that when you are a drug addict or you are an alcoholic and then you immediately stop using okay, these so-called substances, possibilities that you might suffer from withdrawal syndrome. And if you will suffer from withdrawal syndrome, then perhaps you might be thinking of committing suicide. Ibig sabihin, you must be under closer supervision. Okay? Children for that matter. Okay, so children, as much as possible, under the law, Republic Act 9344, okay, the criminal justice system must always endeavor for possibility of intervention or diversion. So without necessarily resorting to confinement. Okay, and then other groups of unusual inmate or offender, of course, the mentally ill. Diba? So mentally ill, they are not normal, okay, and of course, closer supervision is needed for them. Escape-prone prisoner, a suicide risk prisoner, a 6-deviate, itumboy, ibakla for that matter, because possibilities that they could be source of, or they could always be abused for that matter. Those are suffering from physical handicaps, okay, and then of course, aliens, okay, they are considered as unusual inmate or offender. Now, considering that your jail, for that matter, okay, is maintaining several prisoners, okay, so possibilities that you cannot discount possibility that this prisoner would not escape. So if you are going to put anyone or any living creature for that matter in a particular enclosure, tendency is that this animal will always try to escape. The same as true with humans. Okay, when you put human beings into confinement, they will always seek to escape. Okay, the more that they will seek to escape because they are thinking they are irrational human being for that matter. So what are we going to do with this kind of offenders? Okay, so it might we have to ensure, or in the jail for that matter, we always need to ensure that they will be, okay, confined, they will be restricted at all times. So the jail should conduct, okay, a certain number of headcounts. So in relation to that, we have here a question. So what is the minimum number of headcounts that should be conducted on a 24-hour basis? How many times should you conduct headcounts on a 24-hour basis? Okay, take note, we are talking here of minimum. Okay, minimum, you cannot go below that, but you can go higher than that. Okay, so as far as the rules are concerned, okay, this should be conducted at least 4 times on a 24-hour basis. It is randomly conducted. Do not put a schedule on it, because when the offenders, okay, or when the prisoners are already familiar of your routine in conducting head count, then they could use it to work on their own advantage. Okay, and then of course, inside the jail or prison, okay, you have to, what you call this, you have to ensure that contrabands will not, you have to ensure that contrabands will not, you know, will not, okay, you need to ensure that contrabands will not enter the jail or prison facility. Okay, so to ensure that this contraband will not enter the jail or prison facility, it is but important that you have to, you know, you have to screen out any material, any item, okay, that enters the jail or prison facility. Okay, so in relation to that, okay, who will be responsible in the censorship of inmates' mail? Okay, so censorship, why do you need to censor a mail for that matter, or any form of correspondence? Okay, so correspondence, gentlemen and ladies, in the form of mail, okay, or a magazine, okay, newspapers for that matter, everything must be censored, because sometimes these are the sources, okay, of disorders inside the prison or jail for that matter. So as far as the jail is concerned, okay, censorship of mail is being conducted to ensure that only, okay, materials, okay, that are approved by the jail will enter and will be in the possession of the inmate. Okay, so when a letter is sent to an inmate, it is but important that the jail personnel must have to read the content. Okay, will that not be violation of the privacy? It will not be violation of the privacy because it is part of the procedure. Okay, so they will have to read the content to determine whether or not the content is wholesome. Okay, there might be a possibility that the content of the letter is already a plan, okay, for prisoners to escape, something like that. Yeah, so it could be stopped. It could, the jail could have some remedy for it. Okay, so as far as the censorship of inmates mail is concerned, it is, okay, the responsibility of the custodial force. Okay, now when inmates are already inside the prison, of course, or when inmates are already inside the jail, again, as we have made mention, okay, one of the objective of confinement is for the reformation and rehabilitation of the criminal offenders. In relation to that, okay, so what is considered as the cornerstone of prison rehabilitation? Okay, cornerstone, it is the foundation, it is the basic, okay, form of prison rehabilitation. Okay, so for this particular question, our answer here is prison education. Why prison education? Because before you can address any form, okay, of abnormality on the part of the offender, or before any effective rehabilitation is to be undertaken, okay, prison education must be conducted first. Okay, so how could you expect a prisoner, okay, to observe, okay, proper rules and regulation if in the first place he does not know how to read and how to write, so that he cannot read, okay, the prison rules and regulation booklet that you will be giving him? And sometimes also some of the rules are written on the walls. So how would you expect the offender to read the content or the rules, okay, written on the wall if in the first place he does not know how to read and how to write? So we need to teach them how to read and how to write. So it is just a matter of trying to improve, okay, their communication and computation skills, okay, that of course includes the ability to read and write. And in relation to that, okay, what type of prison education is designed to assist adult prisoners or detainees in improving their communication and computation skills, to include the ability to read and write? Okay, so as far as that is concerned, the answer to that is, of course, adult basic education. That includes the elementary education and, of course, the high school education. Okay, how about that particular education program aimed at preparing the inmate for an occupation by acquiring a specific skill that would help them land to permanent job after release? Okay, so the answer to that particular question is, of course, okay, vocational program. Vocational because, again, you will be teaching them some sort of skills for that matter. Now, another question, okay, is kissing and embracing allowed during visits? Okay, is kissing and embracing allowed during visits? Okay, so one of the important, form, okay, of trying to require prisoners to comply with prison rules is, of course, to allow visits from their loved ones. Of course, visitation shall also be regulated for that matter. Okay, so during the conduct of visit, will you allow kissing and embracing during the conduct of visit? Okay, of course, the answer to that question is yes, but of course we have two yeses here. Okay, so the answer to that question is letter A. Yes, provided it must be kept in good taste, not to the point of offending others. So how can kissing offend others? Okay, well, of course, you have to understand that some prisoners, okay, have not been visited, okay, by their loved ones. So showing any intimate activities to them would somehow incite their sexual urges, okay, and of course, okay, it might result to some form of abnormal behavior, abnormal sexual behavior, or sometimes they could also be violent. Okay, so how can you keep kissing, okay, into a good taste? Okay, so huwag kang pupunta ng good taste restaurant, but rather when we say to keep kissing or to kissing good taste is that you have to do it in a simple way. Okay, just a smack. Okay, and no need for you to do it as if you are a bold star for that matter, di ba? Okay, so yan yung natin. Is kissing and embracing allowed during inmates visit? Okay, we have here another question. Judge Supotsky made a telephone call to the jail warden of the Natuli municipality to release SpongeBob for reasons that the case is not covered by the jurisdiction of the judge. If you are the jail warden, will you release the detainee? Okay. So, of course, if you are the judge or if you are the jail warden, you will not release the detainee even if the judge personally called you. Okay, so the answer for this particular question is no, because you have to remember, no offender shall be released on mere order or by telephone call. The inmate shall only be released, okay, upon the receipt of a release order by reason of his acquittal from the case, the dismissal of the case, or after service of sentence, or simply when the person has already paid for his bail or has settled for his bail, and the order of release has been issued, then there is no reason for you to continue holding that particular person. Now, what are the grounds? Again, what are the grounds in order for you to release a prisoner? Of course, service of sentence. Diba? Pangalawa, there is an order of the court. Pangatlo, when the person is granted parole. Pang-apat, when the person is granted pardon, either conditional or absolute. Another is that when he is a political offender and he is covered by a declaration of amnesty or any lawful order of competent authority. So when the mayor, okay, issues a release order addressed to you as jail warden, will you release a person? Okay, for in the release of a prisoner, okay, the mayor is not considered as a competent authority because the competent authority here will only be referring to the court, okay, or other quasi-judicial bodies who are authorized to commit a person, okay, to prison or jail. Okay. Now, when a person is already inside the prison, okay, and after some time they will have to be released. Okay, so the question here is that when shall a prisoner or detainee be informed of his pending release? Okay, at least 1 week, at least 10 days, at least 5 days, at least 1 month. Since we are talking here of the jail, okay, so when a prisoner is about to be released, he needs to be informed at least 7 days, or at least 7 days, or at least 1 week if it is feasible. Okay, well, of course, the idea behind is to prepare them, okay, for their immediate release. Okay, for the next question, it is the actual confinement of a person in an enclosure or in any manner depriving a person of his liberty. Choices are detention, incarceration, imprisonment, deprivation. Now, if you will not be able to get the correct answer for this particular question, it only means one thing, that you are not, or that you have not read your revised penal code. And it is a reminder to all of you that you need to read more. Okay, so for this particular question, our answer here is detention, because the question that we have indicated here is the actual definition of the word detention directly taken from that of the revised penal code. Okay, so basically, when we talk of the so-called detention, it is the act of which a person is placed in a confinement, or there is a restraint, okay, on his person. Okay, and of course, the legal justification for you to be allowed to detain a particular person is, of course, there is a commission of a crime. Okay, and secondly, okay, the person you are detaining is suffering from violent insanity, or perhaps the person is suffering from an ailment that requires compulsory confinement of a patient in a hospital or in a facility for that matter. Okay, so you need to understand that when we talk about the so-called commission of a crime, the crime that is being referred to are those that are penalized under existing laws. Okay, it would not be possible that you will be penalizing a particular person for committing a crime, okay, from which that definition of that crime is only, okay, for that particular person, for that matter. Okay, so let's say, for example, I consider it as a crime and therefore I am going to detain another, then it would be unlawful if the thing that I consider a crime is not legally defined under, okay, legal statutes for that matter. Okay, so we have here another question. Okay, so when a person could move freely outside the jail to take his meals, but is under constant surveillance from the police, is there an act of detention? Okay. Now, as far as jurisprudence, okay, is concerned, you have to understand that originally, as I have made mention a while back, when there is a restraint on the person, then basically it is understood that there is, okay, detention. Okay, so as such, gentlemen and ladies, okay, the so-called or the acts of which after arresting the person, you will now ask him to roam around, okay, but reminding him that he is under constant surveillance. According to jurisprudence, the person is still under detention. Okay, another question. A police officer, seeing his daughter quarreling with her boyfriend, seized the latter and an hour later sent him in the police station for detention and was released the next day. Is the police officer liable for any crime, if any? Okay, so basically, looking at this, scenario, we could now come up with the assumption that the police officer should be held liable for arbitrary detention. For what particular reason? Okay. Now, in this scenario, okay, the daughter and the boyfriend is only quarreling, and you have to remember that quarreling is not a crime. Therefore, it is not a legal ground for the father, okay, to detain, okay, the boyfriend of the daughter. Okay. So in this particular case, again, okay, he is the police officer is guilty or liable, not guilty. He is liable for arbitrary detention. Now, there are there are at least three types of arbitrary detention defined under our revised penal code in relation to Article 124, 125, and 126. Under Article 124, that is the so-called arbitrary detention proper, wherein you detain another without any legal justification, okay, or there is no legal ground for that matter. Okay, arbitrary detention under Article 135 is, of course, under Article 125, okay, is, of course, arresting the person, okay, with legal ground. However, okay, you exceeded the time limit or the period of time allotted for you to detain them, okay, and filing charges. So that is in relation to, you already know this, the 12, 18, and 36 hours rule of detention. And then, of course, Article 126, when you have received an order coming from the court, okay, but you failed to release a particular person, then that is, okay, arbitrary detention, just the same. Now, in the case of this police officer, he is liable for violation of Article 124 of your revised penal code. Okay, I have here another question. PO1 Pogi arrested Pangit while the latter is in the act of stealing the wallet of a passerby. But because PO1 Pogi is out for a date, he detained Pangit in the police station and filed the complaint at the fiscal's office after a day. So is he liable for any offense, if any? So if you are going to consider looking at it, okay, it is filed after a day. And of course, theft here, okay, should have been filed within a period of 12 hours. So therefore, he is liable for violation of Article 125 of your revised penal code, delay in the delivery of arrested person to proper judicial authority. Another question. A policeman arrested B by virtue of a warrant of arrest issued by the RTC of Dagupan City, but the former failed to inform the court about his arrest. Is the policeman liable for arbitrary detention? Okay, particularly on Article 125. Okay, so in this particular scenario, the policeman cannot be held liable for violation of Article 125 or delay in the delivery of arrested person to proper judicial authority. Now, for what reason? Now, Article 125, okay, is intended basically for those people who are arrested without a warrant. But in the case of this policeman arresting B, okay, the arrest was made through a warrant of arrest. The policeman might be liable for administrative charges, but not necessarily on arbitrary detention because the arrest was legal and at the same time it is through the warrant of arrest. Okay, so another question in relation to Article 125. Okay, so we have here Salsalani, who is suspected to be a member of the Abu Sayyaf group, and he was arrested by the members of the Special Action Force. He was detained for 2 days without any charges filed against him. Salsalani filed a case of violation of Article 125 of the RPC, but the court dismissed the case against the policeman. So the question here is that, is the decision of the court in dismissing the case proper? Well, basically, the answer to this question is, of course, yes. The court is correct, considering the fact that under Republic Act 9372, okay, or the Anti-Terrorism Acts, okay, the period of time, okay, for the detention of suspected terrorists is, of course, we have there, okay, 3 days or 72 hours. Okay, now the anti-terror bill that was just recently signed by President Rodrigo Duterte, please try to go over it, okay, since I think there is no implementing rules and regulation yet, okay, there might be an amendment to the period of detention of a suspected, okay, terrorists. Okay. Another. What crime is committed when a public officer, despite order of the court, refuses to release a detainee? So again, this is violation of Article 126 of the Revised Penal Code in relation to delaying release. Okay, another question. A truck driver driving without a license met an accident and was taken to the hospital. And while being guarded by the policeman, he escaped. Are they liable for infidelity in the custody of prisoners? Okay, are they liable, let's say, for example, negligence, okay, or evasion through negligence, something like that? Are they liable? Okay, well, basically, in this scenario, okay, the policeman guarding the truck driver in the hospital is not liable for infidelity. Now, what is the reason behind? The reason behind is that okay, the truck driver is not yet considered arrested, and therefore he is not yet considered as a detention prisoner. So to answer the question, what will consummate the arrest? Okay, so what will consummate the arrest is that okay, the person okay, has been informed of his rights, and at the same time, okay, he is booked for that matter, so that we could consider that he is under detention. In this instance, okay, immediately after that incident, because the first thing that you will need to consider due to the necessity of the circumstances is to bring the truck driver immediately to the hospital. Much more if the truck driver was unconscious after it, then definitely, okay, dalhin mo sa hospital, and therefore you have no time, okay, to effect the so-called arrest. Okay, so when the person is not under arrest, okay, and then he escapes, then there is no way that the policeman will be held criminally liable for infidelity in the custody of prisoners. Okay, how about this one? JO1 Guardia was assigned to guard the prisoners for the graveyard shift. While in his tour of duty, he fell asleep as there are no other entertainment available to keep him awake. As a result, 2 prisoners escaped. So what is the liability of JO1 Guardia? So JO1 Guardia is liable for violation of Article 224 of your revised penal code, and that is evasion through negligence. How can we say that there was evasion through negligence? Of course, JO1 Guardia is a public officer, and as a public officer being a jail guard, he is charged with the conveyance or custody of the prisoner, which is either detention or a sentenced prisoner. And because of his negligence, the prisoner escapes. Okay, so in that case, he is liable for evasion through negligence. It is your job. You are being paid by the government, okay, to ensure that these offenders are kept in isolation. But you fail to do your job and you are liable for it under Article 224. Okay. Now, we also have there another law, okay, in relation to special time allowance. Okay, so what penalty shall be served by a prisoner who escaped on occasion of disorders, conflagrations, earthquakes, or other calamities and did not return within 48 hours following the declaration of the president that the calamity is over? Okay, so basically, when there is a calamity, it is again, okay, an instinct, okay, for human beings to save themselves. Okay, so basically, when you escaped, okay, it's normal. However, okay, within 48 hours after it was declared that the calamity is over, it is expected that you have to go back for, okay, purposes of confinement. Now, if you did not return within 48 hours, then you will be considered as a fugitive. Okay, and at the same time, okay, the moment that you will be arrested, you will be charged, okay, for evasion, and at the same time, the penalty that will be imposed to you will be equivalent to 1/5 of your remaining sentence. So basically, when we are talking about the so-called 1/5 of your remaining sentence, okay, let's say, for example, your penalty is 5 years. And then you have already served, okay, let's say 1 year of imprisonment. And then you escaped after a calamity. So we will have to compute 1/5 of that 4 years, okay? And that would be the penalty that will be imposed, okay, to you the moment that you are found guilty. Now, another question is, what if you return within 48 hours? What if you return within 48 hours? Then if when you return within 58 hours, then you will be given a reward. And the reward that we are referring to is a deduction of your sentence, equivalent to 1/5 computed against your original sentence. So take note of the basis of computation. Kung hindi ka bumalik, bibigyan ka ng penalty, and the basis of computation is your remaining sentence. When you came back within 48 hours, okay, you will be given a reward. And that reward is a deduction of your sentence computed against your, okay, original sentence. But what if you did not escape? Okay, so you did not escape despite the calamity, you did not escape, you remained inside the prison. Under the old provisions of the law, okay, under the old provisions of the law, you are, okay, not entitled to any reward. Okay, however, okay, because the revised penal code was amended, particularly Republic Act 10592 or Republic Act 10592, then definitely you will be entitled. And your entitlement is that when you did not escape, you will be entitled to a deduction of 2/5. Take note, deduction of 2/5 from your original sentence. So your sentence is 5 years. You already served 3 years. There was a calamity. You did not escape. Then definitely you will be entitled to a deduction of 2 years because 2 years was, okay, based from your original sentence. Okay, so that is in relation to Republic Act 10592. And that culminates our lecture series for the subject Correctional Administration 1. Okay, please stay tuned for another lecture series for the subject non-institutional corrections. Gentlemen and ladies, thank you very much for listening.